We have capacity challenges. I'm glad I'm speaking to doctors, glad I'm speaking to the KMA, and capacity issues are perhaps some of the things that we discussed in this conference and what can be done. Yesterday there was a pre-conference with young doctors or upcoming senior doctors, and that would fall right at the center of the conversation that can be had there. But really about skills, modern and effective technologies that can be used in offering abortion, safe abortion for that matter, and post-abortion care for that need to be taken. Lack of training and sensitization on legal provisions. There's something called VCAT, values, clarification, and attitude transformation. I don't know whether that forms part of what is done in the curriculum in medicines, and issues around stigma and how healthcare workers need to engage with people seeking these services in their health facilities. We can speak about health system barriers for safe abortion, and I don't want to preach to the converted because these are stories we speak about every day. Frequent service interruptions, lack of services, and variable availability of these services. Sometimes they are, sometimes they're not. So just recently, healthcare workers have been trooping from one facility to another to seek for the second job, right? Variable availability of services that are key. I know those two are not related, but I could not resist going there. Facility ownership, private and public, also determines whether services can be available, and availability and poor distribution of specialized obstetric and gynecology services, and of course provision of maternity services and family planning methods. The biggest elephant in the room is what's the cost of treating unsafe abortions, and what therefore can need to be done primordially to stop us getting to that point. I think logically it would be right, addressing the unmet need for contraceptives, right? So that people really don't get to the point where they need abortion and they can't get it and therefore go into unsafe, and then we end up with complications that we know how that happens. So family planning would be the logical investment. But that said, we know that unsafe abortion still happens, and the cost of the public healthcare system is quite high. We are actually told that it takes up to around $58, and this was in 2012. If you do an inflation rate, perhaps you're talking about $70 per typical case that comes with complication to the health system, right, of unsafe abortion. And to the healthcare system, it's actually 433 million Kenya shillings nationally. And in 2016, that number went up by a whole 100 million Kenya shillings. So it's really heavy. I mean, if there's something that can be done, the analysis that needs to be done there is what amount would go into providing contraceptives to those people who need the contraceptives. If it's less than that, then it really it makes all the sense to invest in providing contraceptives and modern contraceptives, long-term reversible contraceptives for that matter. Other costs to the economy and families are simply catastrophic. As you can imagine, the scenarios are different from other countries, not very different from other countries in the region. And tackling the root cause of unsafe abortion and intended pregnancies can be done by, like I said, investing in provision of FP services. I'll touch a bit and think on some of the results from this report about the quality of abortion and post-abortion care. If and when it's available, it varies between type of healthcare providers, also type of whether it's a physician or a non-physician. There are all these different levels, and perhaps that questions the whole thing about task shifting, right? What happens when you train non-physicians to provide certain services that are required to be provided by physicians? That's a totally different topic. We can have a conversation about that. Linked to use and non-use of appropriate guidelines and technologies is also something that affects the quality of abortion, post-abortion care. Training, standardization, guidelines, and clarification of legal provision, that falls on the doorstep of the KMA and Kenya Obstetric and Gynecology Society and any other society that deals with clinicians providing services that link to sexual and reproductive health. And of course, the whole issue about comprehensive abortion care, whether it's either been adopted, whether we know about it. Whether it's being implemented or not, that's a different matter, in the sense that Kenya has been a bit reluctant to take the full remit of what comprehensive sexuality education means, and working with the means of education and means of health to actually make this a reality, so that young people, when their informative years, can actually be seized with this information. And finally, like I said, effective contraception is the real deal here. If we can stop it, it doesn't have to happen, right? So people who need contraceptives really then should get them, and therefore primordially, we can stop unsafe abortions from happening. I'm sure, looking at Wangari, I've overshot my time by so much already. So I'll stop there because there are other presenters making their own sectional presentations on this report. And then at the end of the day, we can clarify any issues that are not clear or what you hope to hear from what I presented and you didn't hear. So thank you so much. And back to you, Wangari.
Thank you so much, Dr. Wekesa. So many statistics. I'm sure some of us are wondering, is this how we are going on with all these statistics? I have put together a team of experts who are now going to put these findings into perspective and tell us, what does this mean? Yeah? They are going to tell us, what does the law say? Nerima is going to tell us, is the law clear on access to safe abortion? And then the next speaker, Dr. Odula, is going to tell us, is safe abortion really a public health care concern, or is it just some business we want to run? Yeah. So keep waiting for those presentations and keep tweeting so we give the virtual audience or anyone else that is not here a chance to interact with what it is that we are dealing with. Karibu sana wakili, tell us what the law says about access to safe abortion. Asante.
Good morning, everyone. Good morning. For today, I'll call you colleagues. Good morning, colleagues. I hope you're all well. My apologies, allow me to take off my mask while I'm here for the few minutes that I'll be here. So Wangari has asked me to answer a very difficult question. Is the law clear on matters of safe abortion? Honestly, the law is not clear on anything. And this is the one thing that is good to learn from the onset. The law is not clear on anything. And if any lawyer tells you the law is very clear on this, know you're being lied to. Because there's a number of very many steps that we have to take before we have clarity on what the law says. And usually that clarity only comes when there's a judge that tells you this is what that says and this is what that means. But now in terms for your consumption, what's important to understand, and Dr. Wekesa has really framed it very well. We do have an issue. We have a public health crisis. And it's the fact that a lot of women and girls cannot access safe abortion. And now the question is, can they access safe abortion legally? And the answer is always qualified. Yes, they can, but not in all circumstances. Yes, they can, but not in all circumstances. So now it's for you to make the value judgment of whether or not the circumstances have been met. And the legal framework that guides you in making this value judgment is very extensive. And I'm not expecting anyone to go and get a law degree, but just to have the finer points so that understandably, you're minimizing your legal risk as a practitioner, because there are legal risks that come with providing a service that is in some aspects criminalized. So you have to minimize your own legal risk. You have to give your patients the best standard of healthcare. And at the same time, you have to stay ahead of understanding what your legal obligations are to meet the standard of care. So we have many different frameworks, and unfortunately I can't project, but I've shared this with the KMA team and I'm sure they'll share it. But we have to look at this from 3 levels. We have our national framework, we have our guidance from international law, and then we have counties. And this is where it becomes very important to know the county that I'm in, what is the law on this issue. Because if you're in Makueni County, your obligations as a practitioner are very different than if you're in Kilifi County, because they have specific laws on access to safe abortion. So in your national framework, you're looking at always, the Constitution is your starting point. We call it our Grundnorm, our supreme law, the thing that guides everything that we do going forward. And by we, I don't mean lawyers, I mean all of us, Kenyans. The thing that guides everything that we do. And in our Constitution, a number of things are important. First is Chapter 4 on devolution, which then shares functions between county and national governments on health, stating that the county governments have primary healthcare functions, levels 1 to 5 hospitals, and ambulances, a number of other things, but significantly they also have legislative functions on health. The national government then takes care of tertiary hospital, which is level 6, of which there are 3, and then standard setting. That's the first thing. The next thing is you look at the Bill of Rights. And in the Bill of Rights, there are a number of rights that will guide you on whether or not, when somebody comes into your office, what must I do if she says she needs an abortion, or she needs to terminate a pregnancy, or if the indications for me as I look at this woman is that she might actually require a termination of pregnancy, what must I do? And we have the right to be free from discrimination. That means the right to get health services free from discrimination. And one of the statuses is pregnancy status. Obviously, sex is one of the grounds that are prohibited on discrimination. Secondly, we have Article 43(1)(a), which guarantees the right to the highest attainable standard of health, including reproductive health. And I want to be clear, including reproductive health isn't by chance. The fact that in that entire 20-year negotiation process of, I think, 5 or 6 constitutional drafts, WACI Commission, why reproductive health was highlighted was because of the challenges we've had in the past with guaranteeing reproductive health in this country. It was highlighted for a specific reason, and we have to take that into account when we're offering services. And then we have Article 26(4). And Article 26(4) usually gives us the quagmire that it starts with stating abortion is not permitted. So some people will stop reading there and move. But you have to read the whole article. Abortion is not permitted unless, and this is where it becomes important, in the opinion of a trained healthcare professional. And healthcare professional is defined in the Health Act 2017. And that includes doctors, nurses, clinical officers. So unless, in the opinion of a trained healthcare professional, it is necessary to save the life and health of the pregnant woman. So it's not just life. So previously, prior to the Constitution 2010, life was the only reason which doctors felt they could, and I'm being emphatic on doctors, felt they could venture into providing abortions. But from 2010, you need to consider life and health. And health is also defined in the Health Act, and they use a WHO definition. And it's not just the absence of infirmity, but the complete mental, physical, and social well-being of a person. And then this article goes further and says, unless to save the life and health of a pregnant woman, or if required for emergency treatment, and this is where post-abortion care becomes very important, if required for emergency medical treatment, or if provided for by any other law. So when you see the county government saying abortion is allowed in the case of rape, they're allowed to say that. They have a legislative function. Health is their duty as a government. So if they pass a law that says that, you as a practitioner are obliged to meet the standards of that law. So the Constitution is where we start. Then everything else follows. We look at the Health Act, which gives you the definitions for a healthcare worker or a medical practitioner. It gives you the definition for health. It actually grounds reproductive rights by stating what reproductive rights are in Section 7. And the key things are not just to give reproductive rights, but also have reproductive health information, which is an obligation of both the state and practitioners. And I don't know if anybody was watching the Chief Justice interviews. Maybe it was just lawyers, so watching them with key eagerness. One of the key questions that was asked, I think, to one of the candidates was, does the Constitution apply horizontally? And by horizontally, I mean as like between me and Dr. Were, would it apply? He wasn't sure, but the answer is it does. So not just the state, the government, and people, it's also people as amongst each other. So you could actually violate somebody's constitutional rights, and you could be held liable for violating somebody's constitutional rights if you are not in line with the Constitution in terms of your own practice. So then things like access to information then become important. Being able to provide reproductive health information, you're required to do so in terms of the Constitution, which guarantees access to information, but also in terms of the Health Act, which requires people are given reproductive health information. And by people, it's not just women, girls, boys, men, everyone who requires it. The Health Act also has specific questions around when you have to provide a termination, so complications from pregnancy, which is in section 6, which highlights things like an ectopic pregnancy, which the natural result of will be a termination. So that's when you have to provide one. Then we have the Sexual Offences Act. Important because of a ruling that determined when we say any other law in the Constitution, we mean any other law. The Sexual Offences Act is one such law. And one of the provisions in this act states that the Ministry of Health can make regulations for the management of sexual violence. The Ministry of Health has so done that with the national guidelines on the management of sexual violence, which includes one of the rights of a survivor or a victim of rape as access to termination of pregnancy. That's one of the rights of a survivor. Obviously, I'm sure you're asking yourself a very good question. Me, as a doctor, how would I know? If I come to your office and I tell you, oh my God, I've been raped and I'm not pregnant, and I want to terminate this pregnancy, how would you know? How would you determine? How would you make a determination? Because I can tell you now and for free, there is no way if we waited for a court case to be finalized, anyone would be able to access this right. We actually have a very interesting example from our not really our neighbors, but within the continent. It's in Zimbabwe, where they have a similar provision. You can access a safe termination of pregnancy as a result of rape. A lady was raped, she became pregnant, and it was like a series of unfortunate events. So she went, they couldn't give her post-rape care, or they didn't give her post-rape care. So then that means that resulted in a pregnancy. When she then became pregnant, she tried to have it terminated. Between the police, the prosecutors, no one could agree who should say yes to this happening. And the doctor was like, I'm not sure I can do it unless somebody tells me I can do it. So this quagmire happened, she eventually got to court, and by the time she got a ruling stating she could access a safe abortion, her child was 5. The child was 5. So those are the unfortunate things that happen. The law sometimes moves very slowly. Criminal courts move very slowly. So you find yourself in a quagmire as a doctor. What must I now do? You're saying you've been raped, I don't know. So one county has actually given a solution to this. It states, 1, you can access a termination of pregnancy if you have experienced sexual violence. 2, then it states, it is enough for the person, the doctor, the nurse, the clinical officer offering this termination to receive the testament of the woman to provide the service. So then that gives you legal clearance. So you need to take a recording, a statement, you're told, you give the services. If it turns out thereafter that the person was not being truthful for any reason, then that's not your legal quagmire to bear. That is now the ODPP's work, the police's work to worry about. It's not yours to worry about. But that's from Makueni County. I don't know if anyone here is from Makueni County. So then we also have the standards and guidelines for reducing maternal mortality and morbidity as a result of unsafe abortion. And this has been, I think, a painful journey for many, because we can accept there were guidelines that were necessary, there were guidelines that were needed, and the Ministry of Health produced them after consultation in 2012 and then withdrew them. And after withdrawing them, there was a lengthy court process that reinstated these guidelines, but the Ministry of Health has continued to refuse to send a circular to all public health sector facilities that state the guidelines are in place. So this case was finalized in 2017, if I'm not wrong. We're now in 2021. Because when the Ministry of Health withdrew the guidelines, they also sent a circular saying, stop training, do not provide. Stop training people on comprehensive abortion care, do not provide X medicines in these facilities, right? So now the public health sector is bound by ministerial guidelines. Even when the court says these guidelines are in place, how it works often with the public health sector is unless the directive comes from the ministry itself, they will not move in terms of practice. However, since the guidelines have been reinstated, if you are working in private sector, you are guided by those guidelines. And the good thing about them is that they're quite clear on who can perform what at what stage. When is a nurse able to provide an abortion? When is it required when is it a physician? When do you need an obstetrician? When can you not perform an abortion lawfully? At what stage? Which week? Those are the things that it provides, as well as your requirements as a practitioner to provide these services. It's not just having an office and a consulting room. Obviously, you know this, you are practitioners, but what you require to have in place to be able to provide these services and at what stage. First trimester, second trimester, so on and so forth. Because of the ministry's conduct around these guidelines, they're obviously very difficult to find. They're not on their website. I think very few people still have a hard copy from the time that they were being published. And it's almost a myth at this stage for most people, but they do exist. And if you are in private practice, you can utilize them to guide you. If you are in public, if you work only in the public sector, if you work also in the public sector, you'll have other difficulties because of the ministry circular. So that's where we are with the national framework. The other aspect is that we have to consider international law, because as we have it, Article 260 of the Constitution states that any treaty or convention ratified by Kenya forms part of our law. So it's not just a suggestion, it really is part of our law. And there's a number of different aspects of international law that guide us. Firstly, it's the International Covenant on Economic, Social, and Cultural Rights, and with that covenant, the right to health is guaranteed. But further to that covenant is General Comment number 22 on sexual and reproductive health and rights, which specifically mentions that restricting or criminalizing abortion is a violation of human rights, and also provides the standards under which safe abortion should be provided for women and girls. We also have the International Covenant on Civil and Political Rights, which guarantees against torture. Torture, cruel and inhumane treatment and punishment, guarantees your right to dignity. And if you read this with the Convention Against Torture, cruel and inhumane, degrading treatment and punishment, there has been jurisprudence from the Committee Against Torture that denial of abortion services is cruel and inhumane, degrading treatment and punishment. So this has been a case against Ireland. There's also been jurisprudence from a number of other countries. I think there's a case in the Inter-American Court of Human Rights. It's called KL versus Peru. So Latin America has very restrictive abortion laws in general across the board. But now this is with regards to Peru, and in that case, I think there was a young lady who was pregnant, and since I'm not a doctor, I would pretend to be one, her fetus was incompatible with life. Had it been born alive, it was only going to be alive for all of maybe a few hours or a few seconds, and that was known by the practitioners. But because you're not allowed to access a termination of pregnancy under any circumstances in Peru, she was forced to carry that pregnancy to term, give birth, and then watch said child die. She then obviously, they went to court in Peru that didn't work, and they ended up at the Inter-American Court of Human Rights, which found that forcing her to carry this pregnancy to term, knowing that that child was going to die, was cruel. Because she just knew the entire time. And now you force her to do it, and then when she gives birth, she has to go through the entire trauma of watching a child she carried for 9 months die. So Wangari is telling me I'm quickly running out of time. So let me move a bit faster. So at the international level, we also look at the regional instruments. We have the Maputo Protocol. We have the Maputo Protocol as well as the African Charter. Both guarantee the right to health. The Maputo Protocol has a provision on access to abortion and reproductive health and rights. Kenya has put a reservation on this provision, but given our constitutional framework, it might not be useful. In counties, we have 4 counties with specific laws on reproductive health. So Makueni County, Maternal, Newborn and Child Health Act, Kilifi County, an act similarly named, Kakamega County, an act similarly named, and then the Mombasa County Reproductive Health Services Bill. Of these 4, 2 counties are specifically mentioned termination of pregnancy, Makueni and Kilifi. Makueni quite expansively, indicating when you can access one, including rape and fetal abnormalities. Kilifi, restrictively limiting it to emergency treatment, which is a violation or retrogressive to the Constitution, which also provides it for health and life. And then jurisprudence. The standards and guidelines I mentioned, the case that I mentioned was by FIDA Kenya, actually grounded on a girl who was 14 when she was defiled, had an unsafe abortion, ended up with kidney failure, died by the time this judgment was given. She was 18, she passed away because of the complications from that unsafe abortion. And the court said, in a sense, you cannot force people to continue to carry pregnancy as a result of rape or defilement because she was 14. So whatever the circumstances, she couldn't have given consent. We also have a lot of cases on the right to health, which can be instructive. Importantly for you, the criminal consequences, there could be criminal consequences. An unlawful abortion is not allowed. So what you need to understand is when can you lawfully provide one? And under the circumstances that I've mentioned, you can't lawfully provide one. I think everyone must know the John Nyamu case. There's been more recent ones, Jackson Tally, who was both charged for murder. Eventually they were acquitted, but the trauma of going through a criminal proceedings for providing a health service cannot be understated. And then what role can you play? Minimize your legal risk. Understand when you can provide an abortion lawfully. Follow the guidelines to a T. Keep your records very well. Because if ever it's questioned, your records is what will help us show the court you were not in the wrong. Second thing, participate in legislative processes. There is a KMA bill-making processes for medical practitioners online course. Just participate. We have these processes going on in the counties, in the national government, and we see very few doctors in those processes when they're actually discussing pertinent health issues. And then finally, and always provide the best standard of healthcare for your patients. Thank you, and apologies for taking long.